Okay, stay with me here because what I'm about to walk you through, this is the thing. This is the moment we will look back on and say that's when it all changed. 11 hours ago, while most of America was sleeping, a federal appeals court in Washington, D.C. issued a ruling that, and I need you to understand the weight of this, fundamentally rewrote the rules governing presidential power in the United States of America. If you're just finding this channel, hit that subscribe button right now. Turn on notifications because what's unfolding over the next 72 hours will be studied in law schools for the next century. And you do not want to piece this together after the fact. Let me show you what happened. At 6:47 this morning, Eastern Time, the D.C. Circuit Court of Appeals didn't just deny Donald Trump's emergency stay application. They obliterated his entire legal strategy. And here's the part that matters. Trump's lawyers filed that emergency application at 11 p.m. last night. Less than 8 hours later, the court responded. They didn't schedule oral arguments. They didn't ask for additional briefing. They didn't do any of the things courts do when they're genuinely wrestling with a difficult question. They just said no per curiam. That's the legal term. It means by the court, all three judges, unanimous, no dissent, no reservations, complete agreement. And the language they used, listen to this carefully. Quote, former President Trump's alleged efforts to remain in power despite losing the 2020 election were unprecedented in our nation's history. Now, I've been covering legal proceedings for a long time. Courts don't use the word unprecedented casually. That word is doing enormous work in that sentence. It's saying this isn't a close call. This isn't a novel legal question requiring delicate constitutional balancing. This is a former president who allegedly tried to hold on to power after losing an election. And no version of executive immunity was ever designed to protect that conduct. The court issued 4 critical holdings. Write these down. 1. Complete rejection of absolute immunity. 2. Trump's actions were private, not official acts of the presidency. 3. The charges against him can survive appeal. 4. A legal framework that now applies to every pending criminal case Trump faces, every single one. Here's why this matters in a way cable news isn't explaining properly. Think about the major presidential scandals in American history. Watergate, Iran-Contra, Clinton's impeachment. In every single one of those cases, the president either resigned before criminal prosecution, received a pardon, or faced consequences that never rose to the level of criminal trial. Richard Nixon was pardoned by Gerald Ford before prosecutors could indict him. Ronald Reagan's subordinates took the fall for Iran-Contra. Bill Clinton was impeached but never criminally charged. What's happening right now has no precedent. None. A former president is facing simultaneous criminal prosecution in 4 separate jurisdictions while his immunity defenses collapse in real time. This is constitutional territory the founders anticipated might become necessary but desperately hoped would never be tested. Well, it's being tested now. Now Trump's team had a backup plan. They always have a backup plan. The Supreme Court. 6 conservative justices, 3 of them appointed by Trump himself, Chief Justice John Roberts, who has historically shown concern for the court's institutional reputation. Surely someone on that court would step in, pump the brakes, preserve some measure of dignity for the presidency as an institution. Here's what's actually happening. Radio silence, not from the liberal justices, from the conservatives, from Roberts, from Allo, from Thomas, from the justices Trump himself elevated to the bench, Kavanaugh, Gorsuch, Barrett. Nothing. No emergency intervention, no shadow docket maneuver, no indication that any justice views this case as requiring the court's immediate attention. Senator Lindsey Graham, Republican of South Carolina, one of Trump's most reliable defenders, said this out loud. If the Supreme Court doesn't intervene, we could be looking at a criminally convicted nominee in 2024. A Republican senator talking about the Republican frontrunner. Just saying that in public. If you're finding value in this breakdown, smash that like button. It helps the algorithm push this analysis to people who need to understand what's actually happening, not the sanitized version you're getting elsewhere. Here's where the math becomes brutal. Judge Tanya Chutkan, who's overseeing the federal election interference case in Washington, has invoked the Speedy Trial Act. That statute requires a trial to begin within 70 days once the immunity question becomes final. The appeals clock started ticking this morning, February 12th. That's when the D.C. Circuit is expected to issue its full opinion. That's 28 days from now. After that, prosecutors can push for an immediate trial date, Judge Chutan's original trial date, March 4th. If the Supreme Court declines to intervene, that date becomes immovable, fixed, locked. And here's the thing about unanimous three-judge panel rulings. They almost never get overturned by an en banc review of the full circuit. And the Supreme Court has already declined one immunity-based petition from Trump in this case. The window is closing, the exits are disappearing, and Trump's legal team knows it. I want you to understand what's happening inside Trump's legal operation right now. They've seen the witness list. Mike Pence, his own vice president, Mark Meadows, his own chief of staff, Pat Cipollone, his own White House counsel, Cassidy Hutchinson, who was in the room for everything. They've reviewed the evidence prosecutors have assembled, text messages, emails, phone records, the January 6th footage that the whole world has already seen. They know what's coming. And the response, an endless stream of truth, social posts, all caps, claims of election interference, attacks on Judge Tutcon, accusations of bias, warnings to his supporters. Then came the post that set off alarm bells across every law enforcement agency in Washington. Quote, if these witch hunts don't stop, our country will face problems the likes of which we've never seen. Read that again. A former president facing criminal prosecution for allegedly trying to overturn an election is now threatening civil unrest if the prosecution continues. This isn't political rhetoric. This is potential witness intimidation. This is potential obstruction. Every post he makes becomes evidence. It gets screenshotted, time-stamped, archived, and handed to prosecutors who are building an obstruction case in real time. He cannot stop himself, and every word he types makes their job easier. Washington, D.C. right now looks like it's preparing for war. Capitol Police are on high alert. Security barriers are being erected around the federal courthouse. Counter-protest groups are organizing. Law enforcement is coordinating across multiple agencies. This is day one of a 70-day countdown. FBI threat assessments have been elevated. Joint terrorism task forces are monitoring extremist chatter online. U.S. Marshals are preparing enhanced courtroom security for prosecutors, witnesses, and the judge herself. January 6th taught them not to dismiss this man's rhetoric. 3 years ago, weeks of false fraud claims and calls to fight like hell culminated in a violent attack on the Capitol. The pattern is documented. Officials in Washington aren't sleeping tonight. Let me be specific about what Trump is actually charged with, because this is important. These aren't ambiguous disputes over executive privilege. These aren't routine political disagreements. These are 4 federal criminal counts that go straight to the heart of constitutional democracy: conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, conspiracy against rights, obstruction of an official proceeding, election integrity, the peaceful transfer of power, the core mechanics of democratic governance. That's what's on trial. And the jury pool, Washington, D.C., where Joe Biden received 92.1% of the vote in 2020. Prosecutors aren't relying on hostile witnesses or contested interpretations. They have testimony from Trump's own vice president, his own chief of staff, his own White House counsel, people he chose, people he trusted, people who were there. But wait, even if you think the D.C. case has vulnerabilities, even if you imagine some scenario where Trump escapes conviction there, Georgia is waiting. Fulton County District Attorney Fani Willis Rico charges 19 co-defendants, which means 19 potential cooperating witnesses. And the evidence in Georgia is different, independent, separate from the federal case. There's the recorded phone call. You've heard it. I just want to find 11,680 votes. There's the fake elector scheme, complete with a paper trail showing forged documents submitted to the National Archives. There's the breach of voting systems in Coffee County, Georgia. Different evidence, different statutes, different legal exposure, and none of it depends on federal immunity arguments at all. Georgia is a state case. Federal immunity doctrines don't apply. If you're still watching, drop a comment below. Do you think Trump sees conviction before the election, or does he find a way to delay past November? I genuinely want to know what you're thinking. And Florida, we haven't even talked about Florida. The classified documents case, the boxes at Mar-a-Lago, the materials recovered by the FBI. These aren't routine document disputes, nuclear secrets, military attack plans, intelligence source identities under 18 U.S.C. 793. Retaining classified national defense information carries up to 10 years in prison per count. Trump faces 32 counts, and there's evidence suggesting that surveillance footage at Mar-a-Lago was deleted after subpoenas were issued. If prosecutors can prove Trump directed that deletion, that's obstruction of justice, a serious federal felony carrying up to 20 years. This isn't hypothetical. It's procedural, and it's accelerating. The Republican Party is fracturing in real time. MAGA loyalists are doubling down. Establishment pragmatists are running for the exits. Internal threats are being made against anyone who criticizes Trump. Republican election officials who certified the 2020 results are still receiving death threats. But here's the calculation that's happening behind closed doors in every Republican campaign office in America. Polls show 32% of Republicans say they wouldn't support Trump if he's convicted. 32%. That number makes him unelectable in a general election. Senate Republicans in swing states, Montana, Ohio, Pennsylvania, are already distancing themselves. They know a convicted felon at the top of the ticket drags everyone down, and the 14th Amendment question hasn't been resolved. Section 3, the Insurrection Clause, it bars anyone who engaged in insurrection from holding federal office. No criminal conviction required. Colorado has already removed Trump from their primary ballot. Maine has done the same. The Supreme Court will decide whether those removals stand. The fact that these discussions are happening at the highest levels of government, the fact that constitutional scholars are being consulted about insurrection disqualification tells you exactly how serious this moment is. And here's what's happening outside our borders while we're consumed by this. NATO allies are alarmed. A former U.S. president threatening domestic unrest while facing criminal charges for attempting to overturn an election. This is unprecedented in modern democratic history. Our adversaries are watching, probing for weakness. China is ramping up pressure on Taiwan. Russia is consolidating gains in Ukraine. Iran is expanding uranium enrichment. American domestic instability now carries global consequences. Right now, to the rest of the world, America looks vulnerable. Here's the deeper truth that most analysis is missing entirely. Beyond the immediate legal mechanics, a constitutional reckoning is underway. The D.C. Circuit's decision shattered a long-standing assumption that former presidents occupy a category beyond criminal accountability. That protective wall is gone, demolished. For decades, presidents relied on political norms, institutional deference, avoid explicitly criminal conduct, respect congressional oversight, accept election results peacefully. Those norms are no longer sufficient shields. The judicial rejection of immunity shifts the balance of executive power permanently. It changes the game for every future president, regardless of party. Prosecutors are now operating on a criminal justice clock, not a political calendar. Once that clock starts, it doesn't pause for polls, it doesn't wait for primaries, it doesn't bend to party pressure. Trump's rhetoric has shifted in a way that should alarm everyone paying attention. He's no longer just claiming a witch hunt. He's publicly attacking potential witnesses by name. Mike Pence betrayed him. Bill Barr is disloyal. Mark Meadows is weak. This is textbook witness intimidation, federal crime, 18 U.S.C. 1512. But here's the irony. Every threatening post doesn't freeze institutions. It hardens prosecutorial resolve. Every attack becomes evidence of consciousness of guilt. Every escalation strengthens Jack Smith's case. Trump isn't just factually exposed. He's actively obstructing justice while the prosecution unfolds, and the witnesses know something Trump apparently doesn't understand. Cooperation with prosecutors is now rational self-preservation. Silence is legally dangerous. Once that shift begins among mid-level players, it ripples upward. Flip one co-conspirator and the pressure multiplies on everyone above them. Here's where we stand right now. 28 days until the D.C. Circuit issues its full opinion, 45 days until trial motions are finalized, 70 days until the speedy trial clock expires. Jack Smith has formally declared Trump's immunity claims meritless. The three-judge panel agreed unanimously. The Supreme Court remains silent. Capitol Police are on heightened alert. Criminal investigations are accelerating across 4 jurisdictions. Disqualification arguments are being litigated simultaneously. This is convergence. Everything that's been building over the last 3 years, the January 6th committee evidence, the Mar-a-Lago documents, grand jury testimony, immunity appeals, all of it is colliding into this single narrow window. When Judge Chutkan gavels in opening statements, there will be no ambiguity left. Jurors won't vote on whether they like Trump's policies. They'll vote on documented evidence compiled by federal prosecutors, reinforced by testimony from Trump's own appointees, corroborated by video footage the entire world has seen. No plausible deniability when your vice president testifies against you. No, I barely knew him defense when your chief of staff recounts Oval Office conversations. No perfect call defense when jurors hear the actual recordings. The paper trail is complete. The witness list is devastating. The charges are specific and precise, and if conviction occurs in any jurisdiction before November, sentencing follows. That means a convicted felon becomes the Republican nominee, Secret Service protecting a candidate in detention, campaign appearances reduced to video feeds, a political operation paralyzed by criminal consequences, something without precedent in American history. Trump himself remains the most unstable variable in this equation. His reactions are growing more dangerous, openly authoritarian, increasingly detached from legal reality. Statements warning of chaos if prosecutions continue aren't rhetorical flourishes. They're warning signs. Law enforcement is treating them as such. FBI threat assessments elevated, joint terrorism task forces monitoring extremist communications, U.S. Marshals preparing enhanced courtroom security, protective details for prosecutors, witnesses, and judges activated. History taught these agencies not to dismiss Trump's rhetoric. January 6th followed weeks of false fraud claims and calls to fight. The next 28 days represent the most dangerous window. Trump understands conviction is increasingly likely. Control is slipping. And when Trump feels cornered, he escalates. That pattern is documented throughout his business career, his presidency, his post-P presidency. Jack Smith's investigation doesn't stop with the D.C. indictment. Evidence of witness tampering, obstruction of justice, and conspiracy to obstruct has been transmitted to prosecutors. Multiple grand juries are active simultaneously. Washington, D.C., Miami, Atlanta, New York. State-level charges could emerge even as federal cases proceed. Tax fraud, bank fraud, campaign finance violations, insurance fraud, each moving independently, each creating separate legal exposure. We're in territory the Constitution anticipated, but the founders hoped would never be needed. Multiple accountability mechanisms, firing at once, criminal prosecution, civil litigation, congressional oversight, potential disqualification under the 14th Amendment. Watch what happens within the Republican Party over the next 4 weeks. The fractures forming now aren't temporary coalition stress, they're structural realignment. Once elected Republicans publicly defect from supporting Trump, the dam doesn't rebuild, it breaks. Every new defection makes the next one easier. Every calculated silence speaks louder than any active defense. More adverse court rulings are coming, more damaging witness statements leaking to press, more former officials stepping forward, more Republicans quietly hoping for conviction so they won't have to choose between loyalty and electability. Here's the question that actually matters. This is no longer about whether Trump is convicted. Given the evidence, the witnesses, and the jury pool, conviction in at least one jurisdiction appears increasingly likely. The real question is, what version of American democracy survives after we've stress-tested every institutional guardrail designed to hold presidents accountable? Donald Trump built his entire political persona on the idea that rules don't apply to him, that he's above consequences, that willpower and media manipulation could override institutional limits. What's happening now is the collapse of that belief system, not through rhetoric, through procedure, court orders, jury selection, witness testimony under oath. The criminal justice system is cold, methodical, relentless, indifferent to Trump's rage. Process is the one arena he has never dominated. The countdown is real. The evidentiary record is locked. The next move belongs not to Trump's legal team, but to the federal court system. And that court system doesn't negotiate. The next 10 weeks will determine not just Donald Trump's personal fate, but whether accountability has meaning in American democracy. If you want to stay ahead of the sanitized mainstream narrative and understand the actual legal mechanisms shaping this case, subscribe to this channel right now. We analyze court documents. We decode legal strategy. We track what prosecutors are actually building without the partisan noise. Hit subscribe. Turn on notifications because the next 28 days will move faster than cable news can process. Drop your prediction in the comments. Convicted before the election, or does he delay past November? I'll see you in the next breakdown.